Assalamu alaikum, dear students. Welcome to the class of Business Law. Dear students, today is our ninth lecture. In ninth lecture, we will study the indemnity and guarantee. Dear students, till now, till lecture 8, we studied the contract, the general contract. In general contract, we studied all the terms and conditions, the liabilities, the other topics related to the contract, such as the capacity of parties, the considerations. They were also the essential elements of the contract. We also studied the other essential elements of contract by which the contract becomes voidable, such as coercion, undue influence, fraud, and misrepresentations. These are all the essential elements of a valid contract by which contract becomes voidable. Instead of void, contract becomes voidable. We completed the contract by performance in discharge of contract. In the last lecture, which was lecture 8, today we study the new topic, that is indemnity and guarantee. These are same like the contracts, but these are special kind of contracts. Indemnity and guarantee, both of these contracts are called special kind of contracts. They are special kind of contracts, although these are also contracts. These are also contracts, but these are special kinds of contracts. Special kinds of contracts means they are available some extra terms and conditions and liabilities and rights to the contracts. So therefore, these are called special kinds of contracts. So let me start with the introduction, the lecture objectives. What will be studied in today's lecture? What will be the objectives? These are all objectives of today's lecture. That is indemnity contract, the essential elements of indemnity contract, same like the contract, the rights of indemnity holder. What will be the rights of indemnity holder? What is guarantee? Essential elements of a contract of guarantee, kinds of guarantee, revocation of a continuing guarantee, sureties, liability, rights of surety, and discharge of surety. So let me start with the introduction of the subject. The introduction of the guarantee and indemnity. Before I told you, these both contracts are special types of contracts. Indemnity literally means security against loss. If loss occurs, these losses are secured. The security of these losses is called indemnity. In a contract, when loss exists and these losses are secured by anything, these losses are secured, the security of that losses is called the indemnity. Called the indemnity. In a contract of indemnity, one party, for example the indemnifier, promises to compensate the other party, for example the indemnified, against the loss suffered by the other. It means that there are two persons. One is indemnifier, the person who promises to compensate against the losses. And the second is indemnified, the person who will be compensated for the against of losses. Next is the contract of guarantee, is a contract to perform the promise or discharge the liability of a third person in case of the default. So it means that in the contract of guarantee there are three parties. The one, the principal debtor, the person who make contract with the another person, these two person, and the third person who gives surety to the other third person, to second person, is also available in the contract of guarantee. So there are three persons in the contract of guarantee. If the principal debtor defaults, then all the liabilities of the principal which has been defaulting are transferred to the third person, to the surety. The person who gives the guarantee is called the surety. This is a third person. Third person is called surety. In the contract of guarantee, the person who gives the promise to second person that if the principal debtor defaults, I will be liable for all the liabilities and all the terms of conditions of the contract. So the person is called surety. The person in respect of whose default the guarantee is given is called the principal debtor. It means that the person who acts instead of them is surety, and the person who gives guarantee is called principal debtor, and the person to whom the guarantee is given is called the creditor. So there are three persons in the contract of guarantee. First, we will study the indemnity contract. A contract by which one party promises to save the other from loss. It's a contract. Indemnity contract is a contract in which one party promises to save the other party from loss. Means that Ali promises the Ahmad to save Ahmad from any loss in the contract. So this is called the contract of indemnity. Typical form of contingent contract, it's the same like the contingent contract. If you recall from the previous lectures, we also studied the contingent contract. So indemnity contract is the same contract like the contingent. It's a typical form of contingent contract. Contingent contract means that, if you remember, we studied that Ali want to transfer goods from Jalalabad to Kabul. So if the products are reached to Kabul safely, then the Ali will pay all the price of products to the Ahmad. If Ahmad fails to reach the products to Kabul safely, then Ali will not liable to pay the price of that products to the Ahmad. So this is called contingent contract. If something occurs, then I will do. If something will not occur, I will not do. This is called the contingent contract. In social contract, I can give you an example. I promise to Ali that if he becomes the topper of the class, he holds first position in the class, I will buy a car for him. I will buy a mobile for him. I will buy a laptop for him. So if he becomes topper, then I will buy. If he will not becomes the topper, the first position holder, then I will not buy any laptop or mobile or car for him. So this is contingent contract. The one activity depends on the other activity. It's called the contingent contract. If anything exists, then I will do accordingly. If it will not exist, I will not do accordingly. So the one activity is dependent on the another activity. This is called contingent contract. So the contract of indemnity is same like the contingent contract. It's the form of contingent contract. Contingent contract means that it's a common sense. If losses occur, then I will pay you against the losses. So secured, the losses are secured. If losses will not occur, then I will not liable to pay the against the losses. So this is also a contingent contract. So the losses occurs, then he will do accordingly. If the losses will not occur, then the indemnifier is not liable to pay any type of cost against the losses because there are no losses. So it's also same like the contingent contract. So there are two persons, the indemnifier and the indemnified. The person who will promise for the losses is indemnifier, and the person who will be promised to pay to compensate against the losses is called indemnified. Promiser and promisee. Clear? There are essential elements of indemnity contract. Loss to one party. If one party faced with the losses, the other party is liable to pay against those losses. Indemnity by the promisor will be indemnity holder, indemnity provider. He will be liable for the payment of all losses to the promisee. And reason for loss means that why the indemnity contract exists. What is the reason? Reason is for loss. If loss exists, then the indemnity contract will be made. In any contract, in any general contract, that the indemnifier promise to pay against the losses, the contract becomes indemnity. So this contract is called indemnity contract. So therefore we can say the reason for loss. The formation of indemnity contract is the reason for loss. Why two persons make a contract of indemnity? The reason is for loss. Next, the rights of indemnity holder. What will be the rights of indemnity holder? Right to recover damage. If damages exist, then the indemnity holders has right to recover all damages of the contract. Damages means the destroyment of the objects, or the partially destroyment of the objects, or the variation of the terms and condition of the contract. Any type of damage which occurs in the contract will have the right of the indemnity holder to recover all those damages. Right to recover cost. The indemnity holder also has right to recover cost. Means that when there is damage in the contract and indemnity holder sued for those damages in the court, all the cost which occurs in the case will be recovered from the indemnity holder, from the indemnifier. Right to recover sum paid under compromise. If any type of money, any type of sum paid under the compromise, these sums will be recovered by the indemnity holder. So this also loss. Any type of sum which under the promise paid by the indemnity holder are indemnified, he will have right to recover all those sums, all those money from the indemnifier. And also indemnity holder has a right to sue for specific performance. If any type of specific performance occurred during the contract, so indemnity holder has a right to sue against those specific performance. He will demand from the indemnifier to perform a specific performance in that contract. If exist, if there is no specific performance exists, then it has no, the indemnity holder has no right to sue for that. So it's also contingent. If there is exist of specific performance, existence of specific performance, need of specific performance, then the indemnity holder or indemnified person will sue against the indemnifier to perform specific performance in the contract. And specific performance means if the loss occurred, then this is a specific performance that he will pay the against those losses. So it's a specific performance. So next topic in today's lecture is guarantee. Dear students, you are familiar with guarantee. Maybe possible some of you guys or all of you guys in your life, during your life, you have physically watched or involved you in any type of guarantee contract. Maybe possible. You guaranteed someone, someone guaranteed you. Maybe possible. So it's a very easy and common sense and common topic and very famous topic of the contract, that is guarantee. Contract of guarantee is a contract to perform the promise made under discharge liability incurred by third person in case of his default. In case of his default. There are three parties in a contract of guarantee. The one person, that is surety, who gives the guarantee. The principal debtor, person in respect of whose default the guarantee is given. And creditor, person to whom the guarantee is given. So there are three parties in the guarantee. The guarantee contract may be oral or written. The contract of guarantee may be express or implied and may even be inferred from the course of conduct of the parties concerned. So this is called the contract of guarantee. So dear students, contract of guarantee is not a new thing. It's a very familiar to you. There are three persons in contract. The one person who is surety, who gives the guarantee. The one person who is principal debtor, who will give guarantee to the third person, and third person is a person who will be given with guarantee. That is called creditor. So three persons, the principal debtor, the surety and the creditor. So these three persons combinedly make a contract. So essential elements of a contract. A contract of guarantee can be performed only when certain essential elements the contract are fulfilled. The following are all the essential elements of a contract. So in guarantee contract, all the essential elements of a general contract are also applied to the contract of guarantee. But there are some extra elements are available for the contract of guarantee. Valid contract, same like the general contract. General contract also we said that it's a essential elements of a general contract, that contract must be valid. Tripartite agreement. Tripartite agreement means there are three agreements in the contract of guarantee. Three agreements. Three contracts. The first contract, it's a contract between the principal debtor and the creditor. So it's the first contract on the basis of which a guarantee for the debt arises. The second contract, it is a contract between the principal debtor and the surety. in which the principal debtor accepts the responsibility to indemnify the surety if the payment is required to made by the surety. And the third contract, it is a contract between the creditor and the surety in which the surety promises to undertake the payment of the debts of the principal debtor in case of principal debtor defaults on his payment. So it is tripartite agreement. In contract of guarantee, there are three contracts. So therefore, it is called special kind of contract. So next is consent. We better know. Recall from the previous lectures, we also studied the consent in the general contract. So there must be consent of all the parties in the contract. By coercion, by undue influence, we cannot make any type of contract. So there must be free consent. Free consent of all the parties in the contract of guarantee as well. There should be no misrepresentation of facts. So it's also the essential element of a contract. So facts of the contract must not be misrepresented by any person involved in the contract. For example, the principal debtor also cannot misrepresent the facts of the contract. The surety also cannot misrepresent the facts of the contract, and the creditor also cannot make or misrepresent the facts of the contract. Another essential element of a contract of guarantee is maybe the contract may be oral or writing, and there should be a principal debt or principal debtor. So these are all the essential elements of a guarantee. Kinds of guarantee. There are four types of guarantee. The retrospective guarantee. The retrospective guarantee is a contract of guarantee in which the loss already exists in the guarantee contract. So it's called retrospective guarantee. It means that the contract has been already made. After the formation of guarantee, the surety became the guarantor in the contract. So it's called retrospective guarantee. The prospective guarantee. Prospective guarantee means the contract, the surety in the contract of guarantee will become in the future. Surety enters into the contract of guarantee in the future. So it's called prospective guarantee. Specific guarantee. Specific guarantee means special guarantee of any type of activity or any type of loss. So this guarantee is for single transaction. Specific guarantee is for single transaction. Single transaction means the surety is guarantor for only one transaction. Only one transaction. And the continuing guarantee is against the specific guarantee. Continuing guarantee means the surety is continually guarantor for all the transactions. For example, in continuing guarantee, when I give you example, you will know the meaning of continuing guarantee and specific guarantee. In continuing guarantee, Ali is responsible for collecting all the credits of a organization. So Ali is responsible for the collection of all the account receivables of the organization. So Ali is responsible for whole transactions. We know that any organization has no single creditor, single account pair. The account receivables of the organizations may be possible. There are 10 persons will pay to the organization. There are 12 persons will pay to the organization. So Ali is responsible for all these account receivables. So the Ali is a continually guarantee for all these transactions. So therefore it's called continuing guarantee. Specific guarantee is single transaction and continuing guarantee is multiple transactions. Next, the revocation of a continuing guarantee. How the continuing guarantee is revoked? By notice. Revocation means restricting back, taking back the guarantee of a person. So by notice, you can also revoke your continuing guarantee. By death of surety, a person who dies, then automatic the contract becomes end, and discharge of surety. When all the performance is completed, the surety will be discharged from the guarantee, so it becomes revoked. Next, surety's liability. What will be the liabilities of surety? The person who gives guarantee. The surety's liability is like coextensive. Coextensive means that the surety becomes as principal debtor in the case of principal debtor defaults. Therefore, it's called coextensive. Surety is called coextensive. The liability of surety is coextensive. Coextensive means that it's the surety's liability when the principal debtor becomes default, so the surety becomes the principal debtor, therefore it's called coextensive. Reduction in liability. Reduction in liability means that when the principal debtor defaults or becomes insolvent, so the liability of surety becomes reducted. Reducted means the losses will be shared between the liability and the person of creditor and the person who is guarantor or surety. And the liability of surety is a secondary liability. The first liability is of the principal debtor. When principal debtor becomes default, then after the defaulting of principal debtor, the surety's liability come to exist. So therefore it's called secondary liability. Liability restricted to valid contract. It means that the surety's liability is to restrict the invalid contract. If the contract is invalid, so surety must restrict the invalid contract. So it's liability of surety to make a valid contract. And liability for default by principal debtor. And it comes the liability of surety when default of the principal debtor comes into existence. So these are all the surety's liabilities. Rights of surety. What are the rights of surety against the principal debtor? We can say the right of subrogation. Right of subrogation means the substitution of one person for another. Subrogation means the substitution of one person for another person. Where a guaranteed debt has become due or default of the principal debtor to perform a guaranteed duty has taken place, the surety upon payment or performance of all debt he is liable for. Surety is known as the right of subrogation, namely the right to stand in the shoe of the creditor. So it's a right of subrogation. Means the surety's right to become subrogation, to substitute for the principal debtor. We coextensive before we studied. Right to security. Right to security means the surety is given security. It has right, surety is right to provide him a security by the principal debtor. So it's right of the surety. Right to indemnity. Surety also has right to indemnified. If losses incurs, so surety has right to recover all those losses from the principal debtor. Against the creditor, the surety also has right. So these were the against the principal debtor. Against the principal debtor, he has right to subrogation, he has right to securities, and he has right to indemnity. Against the creditor, the surety also has right to claim securities. So the surety also has right to claim security from the creditor, to claim the security from the debtor, and it also has right to set off. If the creditor sues the surety, he can claim set off or counter claim which the debtor had against the creditor. So it has set off, right of set off, and right of share reduction. Before we studied, it has also the right to share reduction, means that surety has right if the principal debtor becomes insolvent. At the case of insolvency of the principal debtor, the surety has right to share the reduction, to share the losses incurred in the contract. So these are the rights of the surety. Now, the last topic is discharge of surety. How surety becomes discharged from the contract of guarantee? By the notice of revocation. If the notice of revocation is sent to the surety that you are no more guarantor for this contract, for available contract, for existence contract, the surety will becomes discharged from the contract. Death of surety. If the surety dies, so it's common sense, he will be discharged from the contract. Novation. Recall from the previous lecture, we also studied novation in the general contract. Novation means making new contract. If the principal debtor and creditor are agreed to make a new contract and close the existing contract, then surety becomes discharged from the contract. So the surety is also only liable for the existing contract, not for the future contracts. So when the contract is novated, the contract is made for formed new contract, so the surety becomes discharged from the contract. Variance in the terms of contract. If the principal debtor or creditor varies the terms of conditions, contract, or any condition or term is varied from the contract, so the surety becomes discharged from the contract. Or release or discharge of principal debtor. So when the principal debtor is discharged, means completed the contract, performed the contract, so the principal debtor is also discharged from the contract, and the surety is also discharged from the contract, because the contract is performed completely, 100% the contract is performed, and principal debtor released from the contract. So with the release of principal debtor, the surety automatically released from the contract of guarantee. So guys, this was your today's lecture. I hope you got the plenty of knowledge regarding the contract of guarantee and contract of indemnity. These were special kinds of contract. Have a nice time and have a good time. Thank you so much.